S19A 1163, Edward Williams versus DeKalb County et al. John Kennerly for appellant, Bennett Bryan and Brent Herrin for appellees.
Thank you, Your Honors. May it please the Court. I'm Thomas Burch from the University of Georgia. I want to take just a moment to introduce my students to you today, but first I want to say thank you to the Court and to the Clerk, T. Barnes, for making this opportunity available. I could spend the next 20 minutes talking about how meaningful it is to our program, to me and to the students, but mindful of Justice Peterson's words during the swearing-in ceremony. I'll try to keep it brief. And with that, I'll just say thank you sincerely. With that, I'll introduce the two students who helped on the case, Addison Smith and John Lex Kennerly. Both helped on the briefs, and today John Lex Kennerly will be presenting the case on our behalf. Thank you, Your Honors.
Thank you, Professor Burch. Mr. Kennerly?
Yes, thank you, Chief Justice, and may it please the Court. The DeKalb County Board of Commissioners voted themselves a 60% pay increase with inadequate public notice pursuant to a statute that the General Assembly did not have the constitutional authority to pass. This case is about a DeKalb taxpayer holding his county commissioners accountable under the plain text of the Georgia Constitution, the plain text of the Board Member Code of Ethics, and the plain text of the Open Meetings Act. The trial court's decision in this case is inconsistent with that plain text, and it should be reversed. County governing authorities do not have the authority to increase their own pay, and we know this by looking to the county home rule provision in the Georgia Constitution. The county home rule provision grants counties a wide range of legislative power in subparagraph A and B, but in subparagraph C, the county home rule provision says that the power granted to counties in subparagraphs A and B above shall not be construed to extend to any of the following matters. And one of those matters in subparagraph C2 is any action affecting the compensation of the county governing authority. County governing authorities shall not affect their own compensation. Instead of counties having that power, as it says in the main body of subparagraph C, that shall be the subject of general law or the subject of local act of the General Assembly. Now, the trial court in this case, they look to that phrase, shall be the subject of general law, and they reasoned that that phrase empowers the General Assembly to, by general law, delegate to counties even one of these matters listed in subparagraph C that are expressly reserved to the General Assembly. And that's what the General Assembly did in OCGA 36-524, the salary statute. This court should declare that OCGA 36-524 is unconstitutional because the Constitution does not expressly authorize the General Assembly to delegate this power that is expressly reserved in the Constitution.
In fact, counsel, in subsection C of the constitutional provision, it enumerates 8 areas that are off limits to county government. A couple of those actually say unless provided by general law. For instance, counties can't regulate business activities that are also regulated by the PSC in C5 beyond that authorized by law, by local law or general law, which implies that when there's no unless authorized by general law provision, for instance, with respect to C2, that the General Assembly cannot delegate in those contexts. Is that right?
That is correct. That is correct. And subparagraph C, it speaks specifically to things that county governing authorities shall not have the power to have. And if a county is to have a power, is to be given to them by the county home rule provision. The General Assembly cannot give them a power that is expressly reserved here. And if we take the county's reading of the county home rule provision, it essentially says that this is a restriction on counties. This is not a restriction on the General Assembly. That reading of this provision is wrong for several reasons. The first we get from looking to the text of this provision in Article 9. The people of Georgia know what a limitless right to be able to delegate looks like, and that's because we have one in the municipal home rule provision, where it says that the General Assembly is expressly given the authority to delegate its power to municipalities. There's a textual difference between the municipal home rule provision and the county home rule provision, and it's our argument that this textual difference has meaning.
So, Mr. Kennerly, I think the textual constitutional argument is a very interesting one. But before we can get there, my understanding of how the constitutional question is presented in this case is through the procedure of an action under the Declaratory Judgment Act. And the trial court found that your client lacks standing to qualify for qualify judgment. There's not a genuine question, uncertainty about his rights. Why can we get to the merits?
Yeah, so Dr. Williams is a taxpayer in DeKalb County, and this court has held in a number of cases that when a taxpayer is challenging public officials doing something that they do not have the authority to do, and especially, which in this case is a pure expenditure of public funds, that the taxpayer has standing to seek declaratory and injunctive relief. There's a number of cases, King versus Herrin, Savage versus City of Atlanta. In Savage, the claimant there sought declaratory relief and injunctive relief. He was a citizen and taxpayer of the City of Atlanta who was challenging the mayor. He was challenging a number of things, one of those being the mayor and the president of the city council getting an unconstitutional pay increase. And this court found that he had standing to do that.
Before the home rule provisions came into the Constitution in this form, was there a limit on the delegation of the General Assembly? I think there was a different limit on delegations of authority to counties and municipalities. Counties have always been considered subdivisions of the state. Municipalities are municipal corporations. So why, the lead-in language in paragraph C says these enumerated things are not part of the home rule, but they can be the subject of general law.
Yes.
Why isn't 36.524 a general law that deals with this? Well, there's no doubt it is a general law that deals with compensation. So where does it come? Where is the text that says that the General Assembly cannot delegate the power to set salaries?
Yeah, well, so whenever there's I want to point to the Mosley case, Mosley versus Garrett. It's that case that we get the principle that whenever there is an express reservation of power, that when the Constitution speaks specifically as to who it is that can exercise a certain power, any ability to be able to delegate that power needs to be expressed from the Constitution. When the restriction is constitutional, the ability to overcome it needs to also be constitutional.
Well, but you have constitutional language saying these matters which are not automatically given to the counties, because home rule gives a bunch of stuff automatic power to the counties. Here are 8 things that aren't automatically given to the counties, but the General Assembly can provide for them. Yeah. Unless, assuming that such local acts are permitted under the Constitution, but again, before home rule, was there a limitation on the counties being able to increase the compensation of their officials?
Well, so before home rule, all legislative action would have been done by the General Assembly, and counties would not have had that power until the Constitution gave it to them.
So the General Assembly before, I think this came in, I forget, in 1976 maybe, before that, the General Assembly could not allow county authorities to raise their compensation?
Correct. That would have been done by local act.
What is your authority for that? Is there a case saying that?
I don't believe there is a case saying that. I mean, looking into the Mosley case, for example, that was a 1916 amendment to the Constitution that specifically said that the General Assembly can prescribe the salary of certain county officials. So 1966 was where the county home rule provision in its current form was first added to the Constitution. And in 1966, there was already the municipal home rule provision that we've taken a look at that just gives an unlimited right to the General Assembly to be able to delegate power to municipalities. They didn't have that for counties in 1966, so they had to go through the Constitution to be able to give it to them. I'm not sure if that fully answers your question, Justice Namias. So I want to point right now to the first two items in subparagraph C. C1 says that county governing authorities shall not have the power to affect the salaries of elected county officials. This is the sheriff, the tax collector, probate court judge, clerk of the Superior Court.
Those we usually say are not county officers. Those are constitutional officers.
Yes, Your Honor, and they're referred to as in Article 9, Section 1, Paragraph 3, as county officers or elected county officials. And I want to point this out. So number one, county governing authorities can't affect these elected county officials' salaries. And then C2, county governing authorities shall not affect their own salaries. In Article 9, Section 1, Paragraph 3, the Constitution, and this is added for the first time in the 1983 Constitution, expressly authorizes the General Assembly to be able to delegate to county governing authorities the ability to affect the salary of these elected county officials. There is no such right to be able to delegate for C2. And if we take the reading that the trial court took and that the county is arguing for here today, that the language in subparagraph C that shall be the subject of general law allows the General Assembly to not be restricted in their ability to delegate these matters, this is entirely superfluous language that is not necessary. And this is why, and we looked at the transcripts from the 1983 committees. All the committees agreed that the General Assembly did not have the right to do this unless the Constitution expressly authorized it. And so, the county didn't address this point in their brief either. Now,
can we move briefly to the Open Meetings Act issue and the immunity issue? When we look at the official immunity provision of the state constitution, it says that except for certain specified circumstances in that subparagraph D, that no official shall be subjected to suit or liability except as prescribed there, and that can't be waived by statute. Why is a civil penalty, I mean, plainly an Open Meetings Act lawsuit is a suit. Why doesn't that immunity bar your open meetings claim?
So official immunity protects public officials when they're performing discretionary functions and not ministerial functions. So the question here is placing something on the public meeting agenda, a discretionary function or a ministerial function? Well, we look to the Open Meetings Act to get our answer to that question, where, in OCGA 50-14-1E1, it says that all expected items that will be voted on at the meeting, must be placed on the public meeting agenda. So
it seems to me that there's certainly some discretion that's afforded in the Open Meetings Act, right? There are certain things that someone might have to use discretion in the course of a meeting. It says expected, so there are unexpected things. You might have to use your discretion there. But it seems like complying with the Open Meetings Act or the Open Records Act or whatever is not discretionary in and of itself.
That is correct. That is correct. And Justice Warren, in general, they would have discretion as to what goes on to this public meeting agenda. But if it's an expected item, they're required to place it on the public meeting agenda in advance. And
how would you know whether something was an expected item?
Well,
perhaps if it had been advertised for multiple weeks in the newspaper in advance of the meeting?
That is correct, which happened here. They were.
Well, When you advertise it, do you have to put it on the next meeting agenda, or could you potentially put it on a later one, or?
Well, so just to distinguish, there's two separate types of public notice going on here. The Open Meetings Act is specific to putting it on the public meeting agenda. The salary statute, 36524, requires
Right, but the advertising that Justice Peterson was talking about was for the salary increase.
That is correct, and that is proof just straight from the record that the DeKalb County Board of Commissioners knew that they would be voting on this because they were putting it in the news, in the Champion newspaper. So, and not only that, but Dr. Williams alleged that.
Let me ask you this, Counsel. I mean, having lived in local government before, you don't always know whether you're going to put something on the agenda until you know you have the votes. So when would you expect something to be on if perhaps there were informal conversations taking place between members of a city council or a county commission to decide whether, I mean, you don't want to put it on and have it fail. So when would you expect to know for sure something is going on?
Well, so, and that is correct, and that's why the Open Meetings Act allows for items that become necessary during the meeting, that it gives them a break. They don't have to have put it on the public meeting.
Or between the time when the agenda is published and the meeting begins.
That is correct. But the two important things here, two ways that we know that they knew. Number one, Dr. Williams alleged it, and at the motion to dismiss stage, we must accept his allegations as true. And the trial court did not do that. They instead accepted the county's allegations as true. But also, as has been pointed out, the record itself, and you can see, I believe it's Exhibit I on page 90 of the record, shows the advertisement in the Champion newspaper. That was the only public notice that anybody would have had that their county commissioners were going to be giving themselves a 60% pay increase.
What sort of meaning would you give the statutory text becomes necessary to address during the course of the meeting? Does that apply when it simply becomes convenient because I finally decided I have the votes, or is that a higher bar than I've finally been able to count to 4 or 5 or whatever the majority is?
I don't think the language becomes necessary allows for something like whether it will become a successful vote. It just seems whether or not it will be necessary to raise that item.
Is that an analysis that the judicial branch ought to be engaged in?
I don't think so, Your Honor. I think we should be looking to.
Shouldn't there be pretty broad deference to any sort of legislative body to determine when it determines something to be necessary for its conducting of its business?
Well, I don't think so. I mean, the language of the Open Meetings Act is clear that if you know in advance you will be voting on a matter at a meeting.
Sure. The Open Meetings Act prescribes limitations on government for the benefit of the public, right?
That is correct.
And if we were to just defer endlessly to the subjective determination by that limited government agency as to whether the limitation applies, is that consistent with the text of the statute that tells government you can't do this?
The problem here, though, is whether or not it is a violation of the Open Records Act is a different issue than whether or not discretion is involved in deciding what's expected and what's necessary for official immunity purposes. Your client, no one within the time limit prescribed by the Open Records Act filed a challenge to say that this was a violation of the Open Records Act and therefore invalid, right?
Yes, and I want to save some time for rebuttal if I can, Justice Namias. But the Open Meetings Act, these officials, they are bound by this, and the Open Meetings Act makes this a ministerial function. And
Everything that is under the Open Records Act is ministerial.
No, this specific provision that if you know you're going to be, if it's an expected item, you got to put it on there. Period. Yeah.
Thank you, Mr. Kennerly. Mr. Bryan.
Mr. Chief Justice, and may it please the court, my name is Bennett Bryan, and I represent the DeKalb County Commissioners in this case. With the court's indulgence, I would like to reserve 2 minutes of my time for Mr. Brent Herrin to address any questions that you may have regarding CEO Michael Thurman. Now, Dr. Williams filed this action because he believes that the commissioners have no power or should not have the power to raise their own salaries. And the commissioners understand that Dr. Williams has this right to voice his opinion, but the trial court below held that Dr. Williams does not have a viable cause of action, and this court should affirm that decision for 3 reasons. 1, because the General Assembly authorized the commissioners, and specifically the DeKalb County commissioners, to raise their own salaries. 2, because the commissioners complied with the salary statute when they passed the salary ordinance, giving themselves a pay raise. And then 3, even assuming Dr. Williams has standing in this case, my clients are immune based on both official and legislative immunity.
On that last point, is the Open Meetings Act provision imposing the opportunity for civil penalties against violators of the Open Meetings Act, is that unconstitutional? Because in almost all cases, the Open Meetings Act applies to the government. It doesn't apply to private actors unless they've become quasi-government entities.
That's
so
correct, Your Honor.
is a provision that seeks to hold public officials accountable in that way, is that unconstitutional? Is that your claim?
This court must interpret any action of the General Assembly to be consistent with the Constitution. And the Georgia Constitution specifically says that official immunity shall not be waived. And so, unless that is changed.
Well, counsel, the Constitution actually speaks in terms of official immunity from suit and liability for injuries and damages. Now, is a penalty, which is in the nature of a fine, does that fall within injuries or damages? Dr. Williams was not suing to recoup damages for any injuries he personally suffered. Seems to me he was suing in the public interest to impose a authorized civil penalty.
Well, Your Honor, this court explained pretty clearly in Lathrop v. Deal that official immunity applies to retrospective relief, to cure actions of harm already done. And so any harm that would have been done.
I think that was a little bit of a narrower holding.
Would that cut off a criminal prosecution? I mean, in a sense, somebody might have criminal liability to imprisonment or a fine for violating their oath of office.
It is not the county's position, Your Honor, that official immunity would bar a criminal action.
Will distinguish between a punitive fine or penalty and criminal liability.
Well, the nature of a civil action under the Open Meetings Act is, again, there's sort of, we have retrospective looking relief and we have prospective looking relief.
How could the Open Meetings Act ever work with respect to the penalty provision if you couldn't apply it to government actors retrospectively?
Well, Your Honor, there is a remedy. I'm sorry.
There's nobody else that it applies to.
Well, and again, Your Honors, there is a remedy in this case.
But what's the answer to my question? How could it ever apply? How would it exist if it couldn't apply a penalty for conduct that had already happened? We don't levy penalties against people, presuming they're going to do something bad. We wait to see if something happened.
Yes, Your Honor, and that's what, and the constitutional provisions on official immunity do provide opportunities to hold government officials liable for violating the Open Meetings Act, but only if they act with actual malice. And in this case, there are no facts that would support that, as alleged in the complaint.
Explain that to me.
Okay.
How do you piece those things together?
So official immunity, Your Honor, we know protects government officials from their discretionary actions.
Are you presuming that the Open Meetings Act is discretionary to get to the actual malice point?
Well, I think that you have to parse the language of any particular action within the Open Meetings Act. I don't think that we can group the Open Meetings Act as just one provision. There are different provisions with the Open Meeting Act.
But going to actual malice under the circumstances of your case requires viewing that as whatever act is at issue as a discretionary act, not a ministerial one.
Yes, that is correct. It would still only apply if the act would be discretionary, and then the actual malice standard would apply, which again is a very high bar.
We have described actual malice as the knowing or willful doing of an illegal act. Why wasn't this that?
Again, Your Honor, it's not just a knowing and willful. It's something more than that. It's ill will. It's actual malice.
Knowing and willful plus.
Ill will is presumed when you are knowingly breaking the law, when you are knowingly committing a criminal act.
Again, Your Honor, that the criminal act bar is a very hard bar.
If it was knowing and willful, a knowing and willful violation of the Open Meetings Act is a crime.
Again, Your Honor, I believe that actual malice is a different term than just intentional and willful, and there is a substantive difference between those because this court has said on many occasions that actual malice is a very, very high bar.
Can you explain to me again what your best authority is for the proposition that the official immunity from suits and liabilities for injuries and damages extends to a suit to impose a civil penalty to vindicate the public interest?
Well, yes, Your Honor. I mean, in this case, Dr. Williams has said that the purpose for him bringing this is to remedy an injury that the commissioners have committed against.
Did he use the word injury?
Your Honor, I would have to go back and look at the complaint, but either way, at minimum, that's implied that.
Why is that? That goes to your standing point where you say to get a declaratory judgment against the government doing something illegal with its funds, you have to say, well, it somehow specifically and uniquely hurts me. That's kind of a federal thing, but the Georgia cases seem very contrary to that and seem to say that any taxpayer or citizen can sue to make the government follow the law on expenditure of funds.
Yes, Your Honor. And
what's your best case for saying there's something beyond that? Because he's a taxpayer and citizen, right?
It is true. He is a taxpayer citizen, Your Honor. However, I would say the best case would be the SJN property cases, which is cited in our brief, and that's a 2015 case from this court. And the court actually provided a pretty good analysis of what of who may have standing to challenge a statute. And let's be clear, in appellant's argument, the cases cited in favor of standing, which was King v. Herrin and Savage v. City of Atlanta. In those cases, the plaintiff was not challenging the constitutionality of a statute, and so SJN properties, where there is a challenge to the constitutionality of a statute, is more on point, and because in those cases that are distinguishable, the SJN applies. And again, this court has.
So what part of SJN supports your argument that there is no taxpayer standing?
The part on declaratory judgments, Your Honor, it was actually the opinion sort of had a different analysis for the injunctive relief, for the mandamus relief, for the declaratory relief, and this court noted that sure, under the mandamus statute there is public interest in standing under the mandamus statute, but and then also based on this court's past case law, there may be standing for future injunctive relief. But declaratory relief, the court specifically said that there was no standing there because the plaintiffs in those cases did not face any uncertainty as to their rights. There was no uncertainty as to their individual rights.
At the risk of asking an obvious question, if you can't get to this through open meetings and you can't get through this through declaratory relief and you can't get prospective injunctive relief because the notice wasn't given, how can you ever challenge something like this?
Well, again, Your Honor, the Open Meetings Act provides an opportunity. Of course, there is
not the Open Meetings Act. How do you challenge the substantive issue, the constitutional issue?
So the constitutional issue of the statute, in order to challenge the constitutionality of the statute, you have to have an individualized interest.
But who would have that? Or is it your position that the Board of Commissioners can just unconstitutionally vote themselves pay raises with impunity?
No, Your Honor. The commissioners do not take the position that they have impunity. They have authorization under the salary statute.
Let's assume for a second that it was unconstitutional. Who can challenge that?
Someone has a personal interest in that statute.
Wouldn't it be any taxpayer? Because if you live in DeKalb County, your taxes are affected by the salary increase, right?
And again, Your Honor, I think that would provide.
Yes or no? Is that true? If you're a taxpayer in DeKalb County or a citizen in DeKalb County, your rights are affected. Now, they may be affected like everyone else in DeKalb County, but your rights are affected, right?
Yes, Your Honor. The rights to challenge the salary ordinance
Yes.
would be an action of the DeKalb County Board of Commissioners in passing the salary statute or passing the salary ordinance. But again, that is different than challenging a statute itself. And
I do not understand that at all.
So, the challenge is not, the challenge to the statute flows through the challenge to the act of the commissioners. They're saying the commissioners were not authorized to take the vote on the ordinance by the statute because the statute's unconstitutional. It's not a direct challenge to the statute. It's a direct challenge to the vote on the salary ordinance, right?
Well, Your Honor, I do believe that it is a direct challenge to the statute. But even assuming that Dr. Williams would have standing to challenge the salary statute, it is constitutional.
Yeah, maybe you should talk about that, because looking back at SJN, it's obviously distinguishable. It was an issue of whether that taxpayer's own property, they were challenging the assessment of property, which is a whole different thing than something that affects all taxpayers.
Before you get to the merits.
Yes, Your Honor.
You're sneaking up on the answer, I think, of a critical question. Who would have standing to do what, to challenge the pay raise?
Well, I mean, clearly the General Assembly would have
General Assembly
standing.
doesn't have standing. They
nuts.
pass laws.
I'm sorry, the General Assembly has the authority to correct any actions that it believes.
Who has standing to challenge?
Like, would one commissioner have to say to the other, I think you're wrong, I'm going to sue you? Because it's their salary at stake? I mean, I'm really being serious.
Yes, Your Honor. Again, I believe that standing probably would exist to challenge the actions of the DeKalb County Board of Commissioners. But again, the analysis.
Who would have that standing, though?
Any taxpayer or citizen of DeKalb County under dozens of our cases, right?
Again, Your Honor, I believe that it would have to be a personal interest that is beyond just taxpayer standing.
If that is what is required, then the only people, it occurs to me, who could ever challenge it would be one of the commissioners who said, I have uncertainty about whether I legally can take this money, or the treasurer or finance department of the county who says, we're not sure if we're legally authorized to disburse it. And who do they work for? The governing authority. So how likely is it they would actually bring the challenge?
Your Honor, your point is well taken, and again, it's the county's position that
We got your position. You're running out of time. What on the merits of it? Where is the authority of the General Assembly to delegate salary setting to a county?
Well, again, Your Honor, there isn't the word delegate does not appear in the Georgia Constitution's home rule provisions relating to counties. However, the language that does appear is even broader than delegate, and what the subparagraph A of that provision specifically says that the General Assembly has the authority to broaden, limit, or otherwise regulate the legislative power of a county, and in subparagraph C. The subparagraph C says that that county's legislative power is restricted, but not the General Assembly's. And we have to view this both in context, text context, and this court's prior precedents. And in the plain language of the text of subparagraph C says these matters shall be the subject of general law. And the salary statute is a general law. And under the plain language.
Counsel, you said text context, and that's important.
Yes, Your Honor.
Because when you say A, B, and C, I mean, don't we generally say, if we've expressly said one thing, the expression of one thing, right, guides our interpretation. So we say context. You've got a list of things which the county can do, a list of things which the county can't do. And then we say that, but the General Assembly can do things here, and you want us to read that little bit, the General Assembly can do things here, to say, including let the county do the thing that the Constitution says it can't do?
Your Honor, again, the plain text of the Constitution says that these matters shall be the subject of general law. The salary statute is a general law, and this court has said in Gray versus Dixon that this type of general law is the type of general law that's contemplated by subparagraph C.
Well, let me ask this then. Essentially, your understanding of C is the local governing authority cannot do these things unless authorized by general law.
Correct, Your Honor.
So that means we would read C4 to say The local governing authority cannot adopt any form of taxation unless authorized by general law, any form of taxation beyond that authorized by law. So it would become superfluous, the provision in C4 about authorized by law.
Your Honor, I respectfully disagree that would make it superfluous, because that specifically it specifically references local laws related to a particular topic, but the broad topic.
Why would you need that if every subject enumerated in subsection C, if the General Assembly could delegate by general law with respect to every subject in C, why would you need specific authorizations in C4 and 5 for the General Assembly to delegate?
Well, I guess that also, Your Honor, also begs the question that why the introductory paragraph to subparagraph C says shall be the subject of general law, and you have to read that in context with subparagraph A that says that the General Assembly has the power to broaden the county's legislative powers, and again, that would require to hold otherwise would require overruling Gray versus Dixon, which nobody's asked this court to do in this case.
Here's how I understand the general provision in A about the General Assembly can otherwise broaden the authority of the governing authorities. You have an enumeration of things that county governments can do. You have an enumeration of things in C that they generally cannot do, and then you have a whole bunch of things that aren't discussed in the Constitution at all. To me, the catch-all in A is to say the General Assembly gets to decide in that third bucket what the local governments can do and cannot do.
And this court has already decided that even those other powers listed in under subparagraph C that don't include that specific language in 4, that also the general laws authorizing counties to take such actions under those topics is a valid general law, Your Honor.
I get the argument about you can have valid general laws about these topics. My question is, they still have to be valid general laws. And where does the General Assembly get the authority to start with? Put aside home rule. If we didn't have home rule, could the General Assembly pass a general law giving counties the authority to set salaries for their own officers?
Yes, Your Honor. The General Assembly has plenary legislative authority, and unless that is in clear and palpable conflict with the Constitution, that a salary or that a statute shall not be called unconstitutional unless there is a clear and palpable conflict, and where there's a close case, the tie goes to the runner. And this isn't actually a particularly close case, but even if it was, tie goes.
If we talk about palpable, how do you respond to the appellant's point that in a subsequent additional constitutional language we provided for county supplements? Under your reading, that constitutional of this language, C1 and C2, we wouldn't need that additional constitutional language that allowed for county supplements. Is that fair to say? Your reading would say that surplusage that was added later in the Constitution, we didn't need it.
Well, again, Your Honor, I think that, that looking at the text of the provision that is specific to the case in front of us.
But it's specific to the way counties pays employees, whether they be the governing authority or the constitutional officers. They point out that the parallel paragraph, 1 and 2 are right next to each other in subsection C. They point out that there's a separate constitutional provision added later that allows for the supplement. Doesn't that indicate that the people did not believe that to do that they needed to change the Constitution, not a general law?
Well, again, if Your Honor, you're discussing the committee notes or the legislative intent of the drafters of the Constitution.
He's talking about the text.
The actual text that added the provision for local supplements.
Again, local supplements are those apply to other constitutional officers. This specifically has to do with the county governing authority.
Right, but C1 and C2, they're right next to each other.
All right, Mr. Bryan, you asked for 2 minutes for Mr. Herrin. I know we've eaten up a little bit of your time. I'm going to give Mr. Herrin 1 minute if he could do 1 good minute.
Thank you, Mr. Chief Justice.
Thank you, Your Honor. I'll do my best to do this in 1 minute. I'm here today representing the Honorable Michael Thurman, CEO of DeKalb County. In addition to the reasons cited by Mr. Bryan, this court should affirm the trial court's order dismissing my client from this case on the Open Meetings Act claim for a number of reasons. Number one, the appellant doesn't even challenge the dismissal of my client from this case for those reasons. The CEO is not a member of the Board of Commissioners. As a matter of law, he has no authorization to set the agenda for a board meeting. As a factual matter, he didn't set the agenda for this meeting. He didn't ask that this item be added to the agenda. And he didn't vote on the salary ordinance at all. To be liable under the Open Meetings Act, my client would have to engage in a knowing and willful violation or a negligent violation of the act. Here, my client didn't take any action, and as a result of that, this court should affirm the trial court's order dismissing my client from the case. Thank you.
Mr. Herrin. Mr. Kennerly, your rebuttal.
Yes, thank you, Your Honor. The later provision, Article 9, Section 1, Paragraph 3, does contain the word delegate. There's not such an authorization for C2. Regarding the broadening and further defined language, subparagraph C starts out with, the power granted to counties in subparagraphs A and B above shall not be construed to extend to any of the following matters. Everything said above this point, broaden, further define, do not construe that to extend to these following expressly enumerated matters. Finally, we do allege bad faith. Our reply brief, page 14, note 6, shows all the ways in which Dr. Williams alleged that the DeKalb County Board of Commissioners acted in bad faith related to the Open Meetings Act issue. Gray versus...
What's the difference between bad faith and actual malice?
There's not one for this purpose. We don't argue for any distinction there. Regarding Gray versus Dixon, Gray was wrongly decided under the 1976 Constitution, but even so, there are ways that this court can distinguish Gray. There is this addition in the 1983 Constitution relating to C1 that was not in 76. And this court can also salvage the county manager statute 36522. It's not required that this court overrule that. That position of county manager performs an administrative function, and that does not implicate the form of the county governing authority, which is what the prohibition in subparagraph C2 relates to. The county manager performs an administrative function. And lastly, Georgia is a Dillon's Rule state. In Wood versus Gwinnett County, this court said that counties are creatures whose limited powers must be strictly construed. If where we land on this is that the language is ambiguous, thank you, Your Honor.
All right, thank you. Thank you, counsel, for both sides. Professor Burch, I do want to point out that when we discussed this clinic, you committed to vetting the students that you presented and supervising their work, and I have it on good account that you have brought forth 2 Alabama law school students, so we'll deal with that going forward. We'll take a brief recess, 10 minutes. We're going to excuse Justice Warren.